I'll take that conversation forward with Mr. Sidharth Luthra as well. He's a senior advocate, former ASG, who's joining us on the broadcast. Mr. Luthra, thank you so much for joining us on the show. I asked this question to our other panelists as well, including Mr. Anand Grover and Ms. Dr. Abhishek Manu Singhvi, that are they disappointed? I'll ask you the same question. Are you disappointed after what the court has said today?
Yeah, so my answer is straight. I think the court has rightly said it is not their domain to frame legislation. That's definitely not their domain. And by directing that a committee be set up to look into the reforms, I believe the court has done great service to the nation. Having said that, my expectation and my desire would have been that there should have been some view taken on civil rights. And I was hoping that the civil rights, the fact that you should have rights of adoption, maintenance, other civil rights which are relatable to domestic unions, those should have at least been acknowledged and recognized by the court. But perhaps that's also a case that was not entirely argued by either side.
I mean, according to you, with what was read out in the court for about 1.5 hours, and now the judgment copy is also available. But of course, talking about the core reason as to why the court has refused relief, was it surely because there was a mammoth task at hand, over 100 laws that needed to be rationalized, or there was a genuine concern that they would overstep into the domain of the legislature? What is your understanding?
So I think my sense is really it's a question that lies in the domain of the legislature. You're right, there are myriad laws which deal with these issues and the rights of individuals, and therefore those myriad laws, if at all, have to be tinkered with by the legislature and the legislature alone. It cannot be a situation that you have these laws, some which may even be state laws, which are dealt with by a court which perhaps is not aware of the nuances of the various aspects of different laws across the country. Therefore, this is purely and truly a legislative exercise, and the court, in my view, has rightly restrained itself from entering into a legislative domain and has stopped short by giving guidance, by giving protection, directions, certain directions in Justice Chandrachud's judgment, and also expressing a view as to where reform needs to be brought in.
Right.
Very often the court, finding that there's what we call a Lakshman Rekha, stops short of giving certain views, but the silences of these judgments sometimes speak more than their language.
But sir, the other and the counter argument is that the court has overstepped many times, quote unquote. In fact, the Supreme Court has been criticized for often stepping into the domain of the legislature, and the justification has been that the court must take extraordinary steps in the interest of doing the right thing and the interest of justice. Why couldn't the court do it this time?
So it's very simple. There are domains where there is no legislative device that exists, there's no law that exists, and there are international treaties. In such cases, for example, Sakshi, for example, Ritesh Sinha, they've intervened and given directions awaiting the existence or the creation of a law.
Yes.
For example, POCL, before Regulation 419A of the telegraph rules came in, 419A's precursor was the 1997 decision in POCL. That was a decision to fill the gap till law came into being. But the moment the law came, that's 419A came, which has been now amended number of times, you have now a legislative framework. And the written rule, and I will not call it an unwritten rule, is that don't step in when there's a law, or at least, to put it simply, try not to step in where there's a law. And if at all, step in an area where there are international obligations, treaty obligations.
Mr. Luthra, the centre has not been supportive to the cause of the LGBTQ community. Can the community really pin its hope on this committee that was earlier suggested by the centre? And now the Supreme Court is also saying that the committee must look into it. To what extent can the community pin its hope on this particular committee which has been talked about?
I think just because at a point of time, a dispensation was not supporting a certain community does not mean that view cannot change.
Yeah.
These are people we elect. It is for us to choose who we elect. And once we decide to ask uh, political parties to consider their proposals for an election or proposals of their manifestos in terms of the needs and rights of certain communities, including the LGBT community. I believe that change will come. It may not come today, it may come after 5 years, 4 years, 10 years, but there's an election around the corner. I think it's a very important time. The judgments come at an important time when this is a matter which can be raised as a
Okay.
debate in the oncoming elections. It may not occupy the major space, but at least that space has been created, at least that debate has begun.
Absolutely. I agree with you that space is created, that debate is one.